Harlan Ridge, West Virginia. The men who work underground learn early that the mountain keeps its own accounting. That the weight of the rock above them is a debt that comes due when it chooses and not when they are ready for it, and that the people who run the mines prefer that the accounting happen quietly, in the dark, with as little paperwork as the law will allow. For 33 years, the county coroner of Harlan Ridge made sure it did. His name was Vernon Coates, and he had held the elected position of Mercer County coroner since 1988, and he had signed more than 400 death certificates. In that time, and the investigation that finally opened in the spring of 2022, would eventually establish that at least 61 of those certificates were materially false in ways that had served the financial interests of the Caldwell Mining Company, which was the largest employer in Mercer County, and had been since before Vernon Coates was born, and which had paid for his first 2 election campaigns and his office renovation and a truck he drove until it had 180,000 miles on it, and whose general counsel had Vernon's cell phone number and used it, the phone records showed, an average of 11 times in the weeks following any significant underground incident at any of the company's 4 operating shafts. The investigation began not in Harlan Ridge, and not with a phone record, and not with a death certificate at all, but with a lawsuit filed in a federal court in Charleston by a woman named Nadine Prater, whose husband Roy had died in Shaft 4 of the Caldwell No. 3 mine in October of 2019 in what Vernon Coates had certified as an accidental death caused by cardiac failure secondary to exertion in an elevated temperature environment. Nadine had not been satisfied with that determination from the moment the certificate arrived in her mailbox because Roy Prater had been 41 years old and had passed a company physical 6 months before his death without a single cardiac notation, and because 2 men who had been working the same level as Roy that day had told Nadine privately and had declined to put in writing because they still needed their jobs, that the ventilation in Shaft 4 had been failing intermittently for 3 weeks before Roy died, and that the company had been informed and had not fixed it, and that what had killed Roy was not his heart in any meaningful sense, but air that had not been moving the way air in an underground mine is required by federal law to move. Nadine's attorney was a woman named Celeste Drummond, who worked out of a 2-room office in Bluefield and who had handled mining injury claims for 19 years and who had developed over those 19 years a specific and reliable instinct for the difference between a death certificate that was wrong because coroners make mistakes and a death certificate that was wrong because something else was happening. She filed the lawsuit in federal court because the federal mine safety statutes gave her better discovery tools than state court, and she used those tools immediately, requesting, in her first discovery motion, the complete maintenance logs for Shaft 4's ventilation system. For the 18 months preceding Roy Prater's death, the complete set of safety inspection reports filed by the company with the Mine Safety and Health Administration in the same period, in the personnel file of Vernon Coates, including any communications between the coroner's office and the Caldwell Mining Company going back 5 years. The ventilation logs, when they arrived, were exactly what Nadine's 2 informal witnesses had described. The ventilation system on the number 3 level of Shaft 4 had flagged 14 separate alerts in the 22 days before Roy Prater's death, and in 13 of those 14 cases, the corrective action noted in the log was a temporary manual override rather than a repair, a response that pushed the alert off the dashboard for 24 hours while leaving the underlying failure unaddressed. The 14th alert, logged 4 days before Roy died, had no corrective action noted at all. A senior mine safety engineer retained as an expert witness by Celeste Drummond reviewed the logs and produced a report whose conclusions he described as, in his 30 years of reviewing mine safety records, among the most unambiguous he had encountered. The ventilation failure in Shaft 4 in October 2019 had created atmospheric conditions inconsistent with safe human occupation. The cause of Roy Prater's death was not cardiac failure. It was asphyxiation secondary to carbon dioxide accumulation caused by a ventilation system failure that the company had known about, documented, and declined to repair for more than 3 weeks. Vernon Coates had signed a certificate saying otherwise. The second death. Celeste Drummond was not a woman who stopped at the edge of what a single lawsuit required her to find. She requested in a supplementary discovery motion that the company's attorneys opposed vigorously, and the federal judge granted over their objection the complete set of death certificates signed by Vernon Coates in connection with fatalities at any Caldwell Mining Company operation going back to 1995, the year that the company had acquired its current Mercer County operations. There were, the response revealed, 22 such certificates, spanning 27 years, covering deaths had been certified as accidental, natural, or undetermined in circumstances ranging from roof falls to equipment failures to a fire in 2003 that had killed 3 men on the same shift in Shaft 2 of the Caldwell No. 1 mine. Celeste had each of the 22 certificates reviewed by 2 independent forensic pathologists who were given the certificates, the original incident reports filed with MSHA, and the company's internal safety records for each event, and were asked to assess whether the certified cause of death in each case was consistent with the available evidence. In 17 of the 22 cases, both pathologists agreed that the certified cause of death was either accurate or could not be assessed as inaccurate based on available records. In 3 cases, one pathologist flagged a concern and the other found the certification defensible. In 2 cases, both pathologists produced findings substantially identical to what the expert witness had found in Roy Prater's case, a certified cause of death inconsistent with the physical evidence, inconsistent with the incident documentation, and inconsistent with what independent analysis of the circumstances would support in circumstances where the available evidence pointed toward company negligence as a contributing or primary cause. Those 2 cases were the fire victims from 2003. Their names were Luther Mead, 56, Danny Cowan, 34, and Anthony Vernon Pitts, Coates had certified 41. All 3 as accidental deaths caused by smoke inhalation in a fire of undetermined origin. The MSHA investigation at the time had identified the fire's origin as an electrical fault in a pump station on level 2 and had cited the company for failing to maintain the equipment to the required standard, a citation the company had contested and settled for a fine of $42,000, a number that even in 2003 felt to the families of the 3 dead men like a price the company had been prepared to pay. What neither the MSHA investigation nor the families had known at the time, and what the company's own internal records and Celeste Drummond's discovery production now showed, was that the pump station electrical fault had been flagged in an internal safety audit 4 months before the fire, and that the regional operations manager had approved a budget that explicitly deferred the repair to the following fiscal quarter, a decision that pushed the remediation past the date of the fire by 11 weeks, and that Vernon Coates had been informed of the internal audit finding in a phone call from the company's general counsel 2 days before he signed the death certificates for Luther Mead, Danny Cowan, and Anthony Pitts. The phone records. It was the phone records that turned Celeste Drummond's civil lawsuit into a criminal investigation. She had subpoenaed 5 years of communications between Vernon Coates and the Caldwell Mining Company as a discovery matter, expecting to find the kind of casual institutional proximity that was common in a county where the mine was the economic spine of everything. What she found instead was a pattern of contact so specific in its timing that the federal judge reviewing the case notated it in a scheduling order as warranting referral to the United States Attorney's Office for review. In 21 of the 22 mining fatality cases, Vernon Coates had received a call from the company's general counsel, a man named Spencer Aldridge, within 48 hours of the incident and before the death certificate was signed. In 17 of those cases, the call had come before any formal investigation of the incident had been completed. In 9 cases, including Roy Prater's and the 3 fire deaths of 2003, Coates had received multiple calls from Aldridge in the days between the incident and his certification, with the final call in each case occurring within 24 hours of the certificate being signed. The calls averaged 6 minutes in length. Their content was not recorded and could not be subpoenaed. Their pattern spoke for itself. The Federal Investigation, the U.S. Attorney's Office for the Southern District of West Virginia opened a formal criminal investigation. In April of 2021, 18 months after Roy Prater's death, and while Celeste Drummond's civil case was still in discovery, the lead investigator was a federal agent named Christine Holt, who had spent 12 years working healthcare and public corruption cases, and who described in a later interview her first read of the Coates phone records as one of those moments when the shape of something becomes clear before you have any of the specific proof you need, and the only question is how deep the ground goes underneath it. The ground went deep. It went past Vernon Coates and past Spencer Aldridge and into the financial structure of the Caldwell Mining Company itself, specifically into a set of internal reserve accounts maintained by the company's finance department for what internal documents described as contingent liability management, a category of accounting that, in a legitimate corporate environment, would contain funds set aside for expected legal costs, insurance claims, and regulatory penalties. The company's contingent liability management accounts, which investigators reached through a parallel financial subpoena, contained within them a subcategory labeled in a spreadsheet maintained by a senior accountant named Dale Purcell simply as External Affairs, and the disbursements in that subcategory, going back to 1996, included a series of annual payments to a consulting firm registered in Delaware called Appalachian Public Safety Advisory Group, which had no website, no employees, no clients other than the Caldwell Mining Company that investigators could locate, and a registered agent address that turned out to be a mailbox service in Wilmington. The consulting firm had been paid a total of $1.4 million between 1996 and 2020. Its registered manager was a cousin of Vernon Coates, who had died in 2018, and who had, in the years she was alive, told her family that the consulting work involved reviewing mine safety communications on behalf of an unnamed energy client. The bank account attached to the consulting firm had, over 24 years, received those $1.4 million in consulting fees and disbursed from it in regular quarterly payments, approximately $900,000 in wire transfers to a personal account belonging to Vernon Coates. Spencer Aldridge. The company's general counsel, Spencer Aldridge, was 62 years old when the federal investigation reached him in the spring of 2022, and he worked for the Caldwell family's various mining entities since he passed the bar exam in 1985 and had never in 37 years worked for anyone else. He was a man whose professional life and personal life were so deeply interwoven with the company and with Mercer County that investigators found it genuinely difficult at first to find the line between his role as a lawyer and his role as something closer to a family retainer for the Caldwell interests, a person who had over decades absorbed enough of the company's institutional knowledge and enough of its moral flexibility that he had ceased at some point that nobody could pinpoint precisely. To operate as an independent professional exercising legal judgment and had become instead the person who made the calls. He made those calls, the investigation established, according to a protocol that had been in place in some form since at least 1996, and that had evolved over the years from what the earliest records suggested was a relatively informal arrangement. Aldridge calling Coates after incidents to discuss the likely cause of death as a matter of professional courtesy into something considerably more systematic. Aldridge calling Coates after incidents specific information about what the company's internal records showed about safety conditions preceding the death, information that Coates was not entitled to receive before conducting his independent investigation, and that he was certainly not entitled to receive in a phone call from the company's own lawyer. What those calls accomplished, the prosecution would argue, was not the fabrication of causes of death from whole cloth, but something more subtle and more difficult to prosecute. The framing of Coates' investigation in advance, the provision to an elected official of a story that was internally consistent enough to allow a man who needed the money and wanted to keep his job to tell himself he was exercising medical judgment when he was in fact confirming a conclusion that the company had already reached and needed certified. The arrests came in September of 2022. Vernon Coates was charged with 31 counts of filing false official records, 11 counts of obstruction of justice, and 1 count of participating in a corrupt scheme to defraud the federal government in connection with MSHA's regulatory jurisdiction. Spencer Aldridge was charged with 31 counts of wire fraud in connection with the calls, 11 counts of conspiracy, and 1 count of bribery of a public official. Dale Purcell, the company accountant who had maintained the external affairs subcategory for 24 years and who had, he told investigators in a proffer session that lasted 2 days, understood exactly what the payments were for and said nothing because he had a pension vesting in 4 years and a daughter in college and a mortgage on a house in Beckley, and had told himself for 2 decades that the company was just managing its legal exposure the way companies manage their legal exposure, and that the dead men had died in an industry where men died, and that nothing he did or didn't do changed that fundamental fact, which was true. In a narrow sense, and was also the most expensive rationalization he'd ever made because the cooperation agreement he signed in exchange for a reduced charge cost him the pension anyway, and the testimony he gave in exchange for it cost him, the daughter, who has not spoken to him since the proffer became public. He was charged with 1 count of conspiracy to commit wire fraud and pleaded guilty to it in January of 2023. The Caldwell family. The patriarch of the Caldwell Mining Company, a man named Robert Caldwell III, who was 81 years old and had run the company's operations in Mercer County since inheriting them from his father in 1974, was not charged. The investigation found no evidence that he had direct knowledge of the specific arrangement with Vernon Coates, a finding that surprised some of the families of the dead men, and that Christine Holt described carefully in a press conference as reflecting the evidence as it existed rather than any conclusion about what the company's ownership had or had not known. Robert Caldwell III issued a statement through his personal attorney expressing profound sorrow at the deaths of the men named in the indictment and describing the conduct alleged in the criminal charges as a betrayal of his company's values that he had not known about and would not have permitted. That statement was received in Harlan Ridge in the particular way that statements of this kind are received in company towns by people who have spent their lives working for the company and burying people who died working for it, which is with a silence that contains more than it is safe to say. His son, Robert Caldwell IV, who had been the company's chief operating officer since 2015 and who was implicated in no criminal charges, announced in November of 2022, 6 weeks after the arrests, a series of safety infrastructure investments across the company's remaining 3 operating shafts, a figure totaling $23 million, and the appointment of an independent safety oversight board with authority to conduct unannounced inspections and access to all maintenance and incident records. These announcements were received in Harlan Ridge with a more complicated silence, one that acknowledged the reality that the mines were still the mines, and the county was still the county, and the people whose fathers and husbands and brothers had died in those shafts still lived there and still needed the work that the shafts provided, and that the question of how to hold both of those truths at the same time without one of them destroying the other was the question that Mercer County had been living inside for 100 years and was no closer to resolving in 2022 than it had been in 1922. The families. Nadine Prater settled her civil case against the Caldwell Mining Company in March of 2023 for an amount her attorney was prohibited by the settlement agreement from disclosing. In a settlement that also required the company to fund an independent ventilation safety audit at all its active facilities to provide 5 years of safety record transparency to a designated independent monitor, and to establish a memorial fund in the names of the 61 individuals identified in the investigation as having received false certifications. Nadine told a reporter from the Charleston Gazette-Mail in an interview she gave because she wanted something on the record that didn't belong to lawyers, that she had not expected the settlement to feel like closure, and that she had been right not to expect it, and that what she hoped it felt like eventually was accountability, which was a different thing and harder to locate and took longer to know if you had found it. The families of Luther Mead, Danny Cowan, and Anthony Pitts filed their own civil claims after the criminal charges became public, claims complicated by the 20-year gap between the fire and the investigation, and by the deaths of several family members who would have been primary claimants in the intervening years. Luther Mead's widow had died in 2014. His adult children pursued the claim and reached their own settlement in the fall of 2023, also sealed. Danny Cowan's brother, a man named Gerald Cowan, who was 67 and had worked in the same shaft as Danny until a knee injury forced him off the floor in 2009, attended every day of Vernon Coates' trial and did not speak to media and did not file a victim impact statement. And when a reporter
Mara Thibodeau did not tell him he was right.
And asked,
she did not tell him he was wrong.
What he thought of the outcome, he said simply that he thought Roy Prater's wife deserved the credit and that the rest of them had been waiting 20 years for someone to start pulling the thread, and that the thread had been there the whole time. The trial. Vernon Coates went to trial in federal court in Charleston in January of 2024. He was 72 years old, and he was the first person to sit in a Mercer County courtroom on charges like these, and the courtroom was full every day of the 5-week trial, a fact that said something about what the case meant to people who had grown up in the shadow of the Caldwell operations, and who had buried people and been told what they were burying, and who had believed it, or had not believed it, or had believed something in between. That was its own particular and exhausting kind of position to occupy for decades. In a county where the people who needed to be believed were also the people who signed your paycheck. The prosecution built its case on 3 pillars: the phone records, the financial payments, through the consulting firm and the testimony of 2 forensic pathologists who walked the jury through the gap between what the physical evidence in each case supported and what Vernon Coates had put on the certificates. The defense argued that Coates had exercised legitimate medical and professional judgment in each case, that the phone records were consistent with a coroner seeking expert industry context rather than instruction, and that the consulting payments represented legitimate advisory services connected to public safety communications rather than a bribe. The jury deliberated for 3 days and convicted on all counts. Spencer Aldridge pleaded guilty to an amended set of charges in December of 2023, 2 weeks before his own trial was set to begin, in an agreement that required his cooperation with ongoing civil litigation and a full deposition on record with the U.S. Attorney's Office about the complete history of the protocol going back to 1996. That deposition, when its summary was released to the families as part of their civil discovery, contained the detail that everyone in Harlan Ridge had been waiting 27 years to see in writing, that the protocol had been established not by Spencer Aldridge independently, but in a meeting in the summer of 1996 between Aldridge, Vernon, Coates, and a third person whose name was redacted from the public version of the document, and whom the U.S. Attorney's Office declined to identify, citing an ongoing investigative matter that has not, as of this account's compilation, resulted in additional charges. The third person. The redacted name in Spencer Aldridge's cooperation agreement is the one remaining thread in the Harlan Ridge case that the public record contains without resolving. Celeste Drummond, who is no longer the attorney of record in the civil matter, but who has followed its every development, said in a podcast interview in early 2024 that she believes the full picture of what happened in Mercer County between 1996 and 2022 is not yet fully on the record, and that the investigation that produced the Coates and Aldridge charges was a beginning that she hopes will not be treated as a conclusion. Christine Holt, the federal agent who led the investigation, said in the same interview, less directly, but in terms that conveyed the same meaning, that the U.S. Attorney's Office remained interested in the full scope of what the evidence showed and was prepared to go where the evidence led. That is, in the language of federal investigators, as much of a signal as tends to be given before a case is closed, and the people of Harlan Ridge, who have learned over many decades to read what is said about their county in the spaces between the words, understood it accordingly. What Vernon Coates thought of all of it, sitting in federal court and listening to a federal prosecutor describe 33 years of his professional life as a pattern of fraud and corruption, was not something he shared with the court or with the press or with anyone on the record. He said nothing at sentencing, a choice his attorney described as respectful of the court's time and that the families in the gallery described differently. He received 22 years in federal prison, a sentence that, given his age and health, is widely understood to be the legal system's way of saying that he will most likely die there, which is a fact that some of the families found satisfying and some found inadequate, and some found, upon reflection, that they did not have a clean feeling about either way, because the death of a corrupt old man in a federal facility does not restore any of the dead and does not repair any of the safety systems that failed them, and does not
willing to carry, and which parts they have decided
give back any of
without
the years
ceremony
the family spent
and
believing
without
a
a
piece of paper.
particular moment of decision to
That a
set
man
down
had signed
and
for
leave
money,
where they
and
left
that the
them.
satisfaction, such as it is, belongs entirely to the accounting of justice, and not at all to the accounting of loss, which remains what it has always been in Mercer County: large and quiet and ongoing. Celeste Drummond still practices in Bluefield. She took on 2 new mining injury cases in the 12 months after the Coates verdict. She has said that the Prater case changed the way she reads death certificates, which was already a document she read carefully, into a document she now reads. The way you read something you know might be a forgery, with attention to not just what it says, but to the shape of the circumstances around it, the timing of its production and the interests of the people it serves, and the question of who benefits from the story it tells. She has said, when asked whether she thinks other counties have their own Vernon Coates, that she thinks the more honest question is, how many counties do not? And that the answer, based on everything she has seen, is fewer than the people who live in those counties would like to believe. She has not said this to be alarmist. She has said it because she believes it is the truth, and because she thinks the people who are most in a position to benefit from the truth being known are the ones who are underground right now, in the dark, in the mountain's debt, breathing air that is moving or is not moving, and trusting that someone above them is paying attention, which is the most basic and most consequential thing a working miner trusts, and which is, like all trust, only as good as the system behind it and only as strong as the weakest link. In that system, and which in Mercer County for 33 years had a weak link in a county coroner's office on a road off the main highway where a man sat and answered a phone and signed his name. The Shaft 4 ventilation system was repaired in November of 2019, 5 weeks after Roy Prater died under orders from MSHA following the investigation triggered by his death. The repair took 3 days and cost the company $6,800. The foreman who supervised the repair told a safety inspector afterward that it had been a straightforward job, a gasket and a relay switch, the kind of thing that gets deferred because it never quite rises to the top of the list until something happens. He said this without apparent awareness of the weight the statement carried, and the safety inspector wrote it down verbatim in her report, and it is in the record now, as plain as everything else in the record, the gasket and the relay switch and the 3 weeks of alerts and the phone calls and the $900,000 and the name on the certificate and the name on the grave, all of it sitting side by side in the Federal Archive in Charleston, where the case file lives, waiting for whoever needs to read it next. The other 61. The number the investigation produced, 61 death certificates identified as potentially materially false, the number that stayed with Christine Holt the longest after the case was resolved, because it was the number that the prosecution had been least able to do anything with directly. Of the 61, the criminal charges addressed 31, the cases where the evidence was strong enough to meet the federal standard and where the connection to the consulting payment timeline was clear enough to support the wire fraud theory. The remaining 30 were cases where the forensic pathology review had raised questions that the available physical evidence could not resolve definitively, cases where the gap between what Vernon Coates had certified and what the circumstances suggested was real but not provable, cases that lived in the permanent gray zone of an investigation that had come 30 years too late to preserve the physical evidence that would have settled them. The families connected to those 30 cases were informed in a letter from the U.S. Attorney's Office sent in the spring of 2023 that the investigation had reviewed their loved one's death as part of a comprehensive review of the coroner's records and that the review had identified concerns about the accuracy of the certified cause of death, but that the available evidence was insufficient to support criminal charges in connection with their specific case. That letter was written carefully and reviewed by the Victim Assistance Unit before it was sent, and it was still, by every account of every person who received it, one of the worst pieces of mail any of them had ever opened. Because what it said to them between its careful sentences was that something might have been done
Is now
wrong,
trying
but
to
that the
close
system
with
had
varying
decided it could not
resources
prove
and varying urgency and the shared.
it, and that the people most likely to know the truth were either dead or convicted and going to prison, and that the letter in their hands was what justice looked like when it reached its own limit. Some of those families filed civil claims anyway, arguing that the standard of proof in a civil court was lower and that the existing criminal record provided sufficient foundation for a civil wrongful death theory. Some of those claims were still working through the courts at the time this account was compiled. Some families decided that the legal system had taken what it could and that the remainder belonged to them alone, to carry or to set down as they were able, which was a different kind of decision and not a lesser one, and which the legal system has no forms for and no comment about because it operates only where it can reach the miners who are still working. The Caldwell Mining Company's 3 remaining active shafts employed, as of early 2024, approximately 460 men and women across 3 shifts, a number that had declined steadily from over 1,000 in the company's peak years in the late 1980s, and that represented for each of those 460 people a daily calculation that everyone who has never made it tends to underestimate, and everyone who has made it tends to be tired of explaining. The calculation is not simply money against safety, though it is partly that. It is also the specific weight of a place and a trade and a set of skills and a community and a history that have no equivalent in the economy that exists outside the hollow, and that the person making the calculation knows in most cases cannot be picked up and moved intact to somewhere else. Because the somewhere else does not want a miner the way the mine does. And the mine is the mine, and the mine is still running, and 460 people go into it every day, and most of them come back out, and the ventilation systems are now monitored by an independent contractor whose reports go directly to a federal oversight body and not to Spencer Aldridge, and the death certificates are now signed by a physician appointed by the state medical examiner's office rather than by an elected official whose campaign was funded by the company, and those changes are real, and they are not nothing. They are also not the end of the calculation that a miner in Mercer County has to make every morning when the shift starts. They are an improvement in the terms of a bargain that should never have been offered on the terms it was offered, and that the people who accepted those terms were not wrong to accept, because the alternative to accepting was the alternative that people in Harlan Ridge had been looking at since the mines opened, which was less money, less work, less of everything that the Hollow offered in the way of a life, less than what the Hollow offered being already by any external standard. Not much. The mines are still running. The men and women who work them know the record now in a way they did not know it in 2019, and in a way that nobody in Mercer County had fully known it before Nadine Prater's lawyer filed a discovery motion. And the phone records came back. They go in anyway, because they have always gone in anyway, and because going In is what the place requires, and because the calculus of a working miner in a county without options is one that the rest of the country has spent a long time not fully reckoning with, and that the Harlan Ridge case put into a federal record in plain language that anyone who wants to reckon with it now can read. Roy Prater's name is on a memorial wall inside Shaft 4's surface facility, a wall that the company installed in December of 2022 as part of the safety commitment package Robert Caldwell IV announced after the arrests. The wall lists the names of every Caldwell Mining Company worker who died on the job since the company began its Mercer County operations in 1974. There are 47 names on the wall. The question of how many of those 47 should have different causes of death on their certificates, and whether the names now on a company-funded memorial wall represent an accounting or an appropriation, is one that Harlan Ridge is still working out. In the way that communities work out the things that sit inside their history. Without resolution, which is slowly and not without conflict, and with a patience that is different from acceptance even when it looks the same from the outside. Nadine Prater still lives in the house on Claiborne Road where she and Roy lived for 14 years. She told a reporter in the summer of 2023 that she didn't think of herself as a person who had done something, that she had simply not stopped asking the question, and that the answer had eventually come to her because Celeste Drummond was the kind of lawyer who knew where to look and wasn't afraid to look there even when the people who didn't want her looking made it expensive to keep looking. She said she thought about Roy every day in the ordinary way that a person thinks about someone they have lost, and that the case and the verdict and the settlement had not changed the shape of that grief very much, which she had expected, and that what it had changed in a way she had not expected was the shape of her anger, which was different now than it had been in 2019. Not smaller exactly, but more specific, located in a specific set of decisions by specific people who had made them with full knowledge of what they were choosing, and that the specificity, strange as it was to say, was easier to carry than the large and directionless version she had lived with for 3 years before the investigation gave it a shape and a name. The Federal Archive in Charleston holds the full case file, 44 binders, cross-indexed with the civil settlement materials in a separate sealed file. The phone records are in binder 11. The consulting firm's bank records are in binder 14. Vernon Coates' financial records are in binders 15 through 18. The death certificates, all 61 of them, are in binder 1, which is where the investigative team placed them when they organized the file, because the certificates were where the case began and the place it always came back to, the documents that were meant to close a question and had instead, for 33 years, been closing a window that was eventually going to have to be opened, and that Christine Holt and Celeste Drummond, and a woman named Nadine Prater, who had not expected to spend her 40s doing any of this, eventually opened, not with drama. And not with a single decisive moment, but with the patient accumulating weight of every phone record and bank transfer and maintenance log and pathology report and deposition that together built the case that the death certificate had been built to prevent. The mountain keeps its own accounting. The investigation added to it. The record will outlast everyone in it. The coroner's office. The Mercer County Coroner's Office, after Vernon Coates' conviction and removal from the position, was filled on an interim basis by a physician appointed by the state medical examiner, a forensic pathologist named Dr. Lydia Marsh, who drove up from Huntington twice a week and who brought with her a procedural framework so different from what the office had operated on for 33 years that the 3 staff members who had worked under Coates found the transition disorienting in a way they described to investigators as less like a change in leadership and more like a change in what the job was. Under Coates, the office had been a place where a judgment was formed quickly and documented economically, where death certificates were signed within a standard window without elaborate second-guessing of the official incident report, and where the relationship between the office and the county's major employers had been, if not warm, at least frictionless. Under Lydia Marsh, every industrial fatality required an independent scene examination, independent toxicology, documentation sufficient to withstand review by a physician who had not been present, which is the standard that the office should have been operating at since the day. Vernon Coates first took the position in 1988 and was instead the standard that it arrived at after 33 years of his not operating at it. One of those 3 staff members, a records clerk named Donna Sewell, who had worked in the office for 18 years, told Christine Holt in a voluntary interview that she had known in the way you know something you never fully let yourself finish the thought about that there was something off about certain cases, that the calls from Spencer Aldridge's number before a certificate was signed had been a pattern she had noticed without naming, and that the pattern had sat inside her. The way things sit inside a person who needs their job and has children. In school, and has constructed, over 18 years, a professional identity around being good at her work and not asking questions whose answers would require her to stop being good at her work and start being something more difficult. She had not been aware of the consulting firm payments or the bank transfers,
Identity is built around
which had been arranged without any footprint in the coroner's office records. She had been aware of the phone calls because she sometimes transferred them to Vernon's private line and noted them in the office log, and she had for 18 years noted them and not looked at them as a group and not counted them and not asked why they were always before and never after the certificate was signed. She told Christine Holt this in a tone that Holt described afterward as the tone of a person who has decided that the complete truth is the only thing left that is fully hers to give, and who is giving it because not giving it has cost her more than giving it will. Donna Sewell still works in the coroner's office. She works now under a physician who does the job the way it is supposed to be done, and she does her job the way it is supposed to be done, and the transfer log no longer records calls from the Caldwell company's general counsel because there is no longer a general counsel willing to make them and no longer a coroner willing to take them, and the office is, as far as anyone can assess from the outside, what it was always supposed to be, a place where the county's dead are given an accurate accounting of how they became the county's dead, which is the minimum the dead are owed, and the minimum the living who come after them deserve to have on the record, so that the record says what happened rather than what it was convenient. In 2003 or 2012 or 2019, for a company with 4 active shafts and a general counsel with a phone and a protocol to have the record say. The ventilation relay switch that was never replaced in shaft 4 until after Roy Prater died cost $6,800 to fix and is still in there now, working the way it was always supposed to work, moving air through the mountain. The way air has to move for the people inside the mountain to breathe. Doing the thing that it was built to do and that it had been failing to do for 3 weeks in October 2019 while 14 alerts logged themselves in a maintenance system that a man in an office above ground read and overrode because the repair would have come out of a budget he had already allocated elsewhere. The Switch does not know any of this. The Mountain does not know any of this. The people who go underground every morning and breathe the air that the Switch now moves the way it is supposed to move are not thinking about the Switch. They are thinking about the work. The Switch just works. That is what $6,800 and a dead man and a 3-year federal investigation and 44 binders in a federal archive in Charleston bought for Shaft 4 of the Caldwell number. 3. Mine. A relay switch that works. It is not enough. It is also what there is. What the country knows and does not know. The Harlan Ridge case received moderate national media coverage in the weeks following the arrests and stronger coverage during the trial, and it receded from national attention after the verdict in the way that cases involving industries and communities that the national media understands as geographically and culturally remote tend to recede, which is quickly and without much sense of the continuing weight of what they leave behind. The people of Mercer County read their own story told back to them in language that felt, to most of them, like a translation into a dialect that captured some of the facts and almost none of the texture. A translation that made the story about corruption in the abstract, about a bad official and a company that paid him in a frame that placed the wrongdoing at the level of the institution rather than in the physical reality of a man breathing bad air in a tunnel 1,000 feet underground, while the people responsible for that air had decided in an office above ground that the cost of fixing it could wait. The distinction between those two frames is not a subtle one to anyone who has worked underground or who has grown up in a community built on underground work. The institutional frame is the one the law uses because the law needs to prosecute specific acts committed by specific people, and the institutional frame gives it the tools to do that. The physical frame is the one that lives in the bodies of the people who go down every morning in the specific knowledge of what it is to breathe air that is moving and what it is to breathe air that is not, in the understanding that the space between those two things is the space between living and dying, and that the person responsible for which side of that space you are on today is not an abstraction, and not a system, and not a culture, but a specific human being who made a specific decision and who had, in Mercer County for 33 years, a specific human being in a specific office willing to sign his name in a way that made the decision disappear into the record as something other than what it was. Federal Mine Safety and Health Administration. In the 2 years following the Coates charges, MSHA undertook a review of its own inspection records for Caldwell Mining Company facilities going back to 1996, a review that it announced publicly, and that produced, after 14 months, a report that identified 23 instances in which MSHA inspection findings had been closed without adequate follow-up in circumstances where the company had contested a citation and the coroner's office had already certified a related fatality as accidental. The report's conclusions were cautious and institutional in their language, describing the findings as reflecting systemic gaps in interagency information sharing rather than improper conduct by MSHA a characterization personnel that the agency's inspector general said reflected the evidence as it existed, while also noting in a separate memorandum that was technically not part of the official report, but that was released alongside it, that the information sharing gaps identified were not gaps in the passive sense of oversights, but gaps in the active sense of a system that had been designed at the level of the regulatory framework to rely on local officials whose independence from the entities they were meant to provide oversight of had never been adequately assured. That memorandum used the word coroner exactly once, in a sentence that the people who read it carefully understood as a sentence pointing at every county and every state where an elected or appointed local official held a role that the federal regulatory system depended on and whose independence from local economic power had been taken on faith rather than verified by design. The memo did not name those counties. It did not need to. Anyone in the relevant field who read it was already thinking of 3 or 4. The question that the memo posed, without quite asking it directly, was a structural one rather than a criminal one, and it was the question that Christine Holt returned to in her own thinking about the case more often than the specific facts of what Vernon Coates had done. The question was whether a system that relies on the integrity of an individual in a locally accountable position to serve as a check on the conduct of the most economically powerful entity in that individual's community has, in any meaningful sense, designed a check at all. The answer Harlan Ridge had demonstrated across 33 years and 61 death certificates that it had designed the appearance of a check. The appearance had worked well enough for 33 years, which is to say it had worked well enough for the company, which is to say it had not worked at all for Roy Prater or Luther Mead or Danny Cowan or Anthony Pitts or the 57 other people whose certificates now had question marks attached to them that the legal system had decided it could not convert into charges. The appearance of a check is not a check. The record of Harlan Ridge is, among other things, a very long and expensive demonstration of that distinction, written in the names of the dead and filed in 44 binders in a federal building in a city that most of the people those names belonged to had never visited. The Hollow in winter. People who have never spent time in a southern West Virginia coal community in winter tend to imagine it through the visual grammar of poverty, which is accurate as far as it goes, and goes nowhere near far enough. The Hollow in winter is also a place of a specific and intense domestic warmth of kitchens lit against the dark before 5 in the morning when the early shift has to eat, of the particular social gravity of a community that has weathered enough together to have developed, without discussing it, an understanding of what the others need and when to provide it. The funerals in Mercer County when a miner dies are attended by everyone who knew him, which in a hollow where everyone knows everyone is effectively everyone, and the food that arrives at the widow's house in the days afterward comes in quantities that say something about the way the
She stays for about an
community
hour
understands
and then
loss
drives
as a
home,
communal
and she does not.
event rather than a private one, as something that has happened to all of them rather than only to the family, which is partly solidarity and partly the honest understanding shared by everyone in the room that it could have been any of them, that it will be some of them, that the Mountains accounting does. Not distinguish between the careful and the careless with the precision that the people above ground would prefer. Nadine Prater received that food in October of 2019. She received it from people who had known Roy and people who had barely known him and people who knew what it meant to have your husband not come home from the shaft, and who brought what they brought, because that is what you do, and because in a hollow, the thing you do is often also the only thing available to do. She received it, and she thanked people, and she put it in the refrigerator. And she sat with her grief in the way you sit with grief in. The first weeks when it is still too large to see around, and at some point in those first weeks, she picked up the phone and called Celeste. Drummond's office in Bluefield, because the certificate in her mailbox said cardiac failure, and Roy had been 41 years old and had passed a physical 6 months earlier. Without a single cardiac notation, and something in Nadine Prater sitting in a house, full of casseroles brought by people who understood loss in their bones, decided that the certificate was wrong and that she was going to find out how wrong. And why. She has been asked in several interviews where that decision came from, whether it was anger or love or stubbornness or some combination she couldn't separate. She has said that she doesn't think it came from any of those things. Exactly, that it came from something more like clarity, a specific and undecorated clarity about the gap between what the paper said and what she knew, and that the gap was too large to close by any means she had available except asking someone who knew how to ask the right questions in the right places, with the right tools. She found someone who could do that. The questions got asked. The answers came back. The record changed. Roy Prater's death is now recorded in the federal criminal record, if not yet, on the original state certificate as what it was. Not a cardiac event, not an act of the mountain, not the sad and foreseen consequence of a hard industry, but the specific and preventable result of a specific decision by specific people. To defer a $6,800 repair, compounded by the specific and paid decision of a county coroner to write it down as something else. That is what happened. It is in the record. It will stay there. The relay switch works. The ventilation moves. The shaft is dark. The work continues.